was found to be unconstitutional. We've had a couple of decisions, one in the Federal Court of Appeal several months ago in a case called Stakopoulos versus Canada, and another one in the case that I and John Conroy handled on behalf of a marijuana grower for the Vancouver Island Compassion Society and the Medicinal Cannabis Dispensary called R.V. Barron, and that was in BC Supreme Court. That sort of takes us to today in the legal history of this program. It is clear to me and undoubtedly true that there will be more lawsuits, that Health Canada will be sued again, and that we will continue to have to fight our way in the courts to get Canadians the protection they deserve when they access marijuana for legitimate medical purposes. But to talk just briefly about the MMAR and how that scheme looks today, and I can get into sort of the details of the court decisions as we go along or any questions. But the system as it stands today is an exemption system. In other words, marijuana is illegal to possess, illegal to traffic, and illegal to produce. You can't buy it, can't sell it, can't possess it, you can't cultivate it, unless you have a license from Health Canada. Health Canada will issue you a license if you meet certain criteria set out in the MMAR. Now, there are sort of two pieces to the MMAR. There's the access piece. How do you get legal protection from the criminal law? And there's the supply piece. Where are you going to get your marijuana from once you have this legal protection from the criminal law? The access piece, in my view, is currently the most problematic area of the regulations. Since the program's inception in 2001 through the present day, approximately 3,000 to 3,500 people have become licensed legal medicinal users of cannabis. They have a license that allows them to possess marijuana in accordance with the terms of their license, so in quantities that are specified on the license, and if they're within those quantities, then they're not breaking the law. They are exempt from the application of criminal law. The problem is that if you look at the most recent data on this issue collected by the government, which was in 2005, the Canadian Centre for Substance Abuse did a pretty comprehensive survey on drug use in Canada, and approximately 1 million people self-reported medical marijuana use. Other estimates have ranged in the 400 to 600,000 people range. So you can see if you have an exemption process that 3,000 people managed to access over an 8-year span, but a million, anywhere from 400,000 to a million Canadians are using medical marijuana, there's a disconnect. There's a disconnect between who's actually in need of medical marijuana and who's actually able to benefit from legal protections and therefore not put their liberty, because you can be arrested for possession and put in jail, or their security of the person, because sometimes as an illegal user you have to access marijuana in unsafe ways, an unknown product from unknown suppliers, and that puts your health at risk, particularly if you're already health compromised. I think this is the biggest problem with the program now, and it results, I think, from the government's criteria. And the government is basically broken, and Randy's been good enough to print out both the government's applicant guide as well as the full stack of forms that you can review and fill out if you want to seek an exemption from the government. But the access piece is broken into sort of two categories. There's category 1 and category 2. There used to be a category 3. Categories 2 and 3 were consolidated in 2003 as a result of one of these court decisions and finding unconstitutionality. But category 1 is, I guess what I characterize as the same kind of people that Dana's mentioned, who his dispensary will accept as just a confirmation of diagnosis. These are the conditions for which there's universal agreement that marijuana provides some medicinal benefit. And so the government has lumped these into about 7 categories: multiple sclerosis, spinal cord injury, spinal cord disease, cancer, AIDS, HIV infection, severe arthritis, and epilepsy. It's almost unquestioned. It is unquestionable in the scientific literature, and the government's expert conceded all of this on the stand at trial, that for those conditions and the symptoms that they present, severe pain, muscle spasms, cachexia, anorexia, weight loss, nausea, seizures, marijuana and marijuana products indisputably provide a measure of relief to people. If you're in those categories, suffering from those conditions with those symptoms, you can take this form B1 to your medical practitioner. It can be just a general practitioner, but it does have to be an allopathic physician. It cannot be a naturopath, cannot be a doctor of traditional Chinese medicine, cannot be a registered nurse. Those are all provincially regulated healthcare professionals. None of them can sign these forms. Only MDs can sign these forms. You take this form into your healthcare practitioner, you fill it out completely. There's a little check the box area for your symptom and your condition. You have to be in one of those intersections. Your doctor fills it out. You come up with a proposed daily amount of marijuana use that will determine how much you're entitled to possess on your person at any one time or in your home for storage purposes. And then the medical practitioner makes a couple of declarations that you in fact suffer from that category 1 symptom, that conventional treatments have been tried or considered and have been found ineffective or medically inappropriate for the treatment of the applicant, that no notice of compliance has been issued for marijuana under the Food and Drug Regulations, and that everything on the form is true and accurate. You sign this, you get that filled out, you get a couple of passport photos, you fill out Form A. Form A is your authorization, your application for the authorization to possess. This is where you make your declarations about marijuana and yourself, your condition, and where you propose to get marijuana from, and that you understand that marijuana is potentially exceedingly risky, and that you've talked to your physician, and all these kinds of things. You send these 2 forms in. The government Medical Marijuana Access Division then reviews the forms, and if it is a properly completed form, and you meet the requirements of the regulations, there's no discretion to say no. The government must issue an authorization to possess. The processing period averages about 8 weeks for persons with seeking amounts above about 5 grams of marijuana usage per day, which is a lot more common than most people might think. The processing period can go 10, 12. I've had clients in the 8-month range for the government to process their applications. Now, granted, those people were seeking what I would characterize as exceedingly high levels of daily usage, but the reality is the government doesn't have any discretion to say no. If there's a properly completed form, they should process it and send it in. Why people might use exceedingly high levels of marijuana on a daily basis varies with the patient. I'm sure we're all familiar with people who have, for example, an incredibly high tolerance to opiate-based painkillers because they've been living with chronic pain for 20 years. And if you walked into a doctor's office and asked for that on day 1, the doctor's going to think you'll be dead by the time you walk out the door, right? But if you built your tolerance to that point, and that's what you need, and your doctor will sign for it, that's all we require for some of these very dangerous drugs. In my view, that's all we should require for marijuana, much more safe alternative to opiate-based painkillers, especially for chronic pain. Category 2 is everything else. So if you're not in that category 1, you're automatically in category 2. And category 2 has a bit more onerous requirements. You have to fill out the Form A. You have to fill out the Form B2, not B1, but B2. Form B2 has all the same information as B1, except it also requires your doctor to declare that either your doctor is a medical specialist in an area of medical specialization relevant to the treatment of the applicant's medical condition, or if you're not a medical specialist, the general practitioner is probably not a medical specialist, that you've consulted with a medical specialist, the applicant's case has been reviewed by that specialist, specialist area of specialization is relevant to the area of the condition, specialist concurs that conventional treatments for the symptom are ineffective or medically inappropriate, the specialist is aware that marijuana is being considered. So that becomes obviously a bit more onerous.
Now, can a naturopath fill out the Form B2?
No.
Does it have to be?
And the Form B2 again,
Naturopath would do.
no, naturopaths are not recognized by Health Canada as being able to sign any of these forms. The Form B2 is still signed by your general practitioner or a specialist, but your general practitioner, if not a specialist, him or herself, must consult with a specialist that's reviewed your case. And anyone that's had to see a specialist for any medical condition understands that this adds a fairly significant time burden to the process. You have to renew these forms every year, and so you begin to hit a sort of situation where it's cumbersome, it's difficult, it's particularly difficult in my view for persons that are disabled, that are dealing with serious chronic conditions.